Thanks very much for viewing this video. I'm patent attorney Steve Keefe. This is Decision Point, a series of brief videos to inform IP decision making by innovative enterprises. Today's topic is global patent filing deadlines. Global patent filing begins with a first filing. For this video, we'll assume it's in the US. You want to get that first US application in prior to any type of public disclosure, such as speaking about your invention publicly, speaking to third parties without an NDA, public sale, or offer to sale. Once you have that first application in, you can use the term patent pending. You can use that on your marketing materials, when speaking to investors, with any activity, business activity regarding your invention. The first deadline you have to worry about after your first filing is the 12-month deadline. You need to have your foreign filings either completed or initiated with a PCT by the 12-month deadline. Just as a quick note, patent law is territorial. For each nation you want patent protection in, you need to individually prosecute a patent in that jurisdiction, whether it be a nation or a region such as Europe. The first way you can do that is with direct foreign filings. That is, you using your first filing as priority, you file directly in a foreign country. For example, if you want Brazil, Germany, France, and China for patent protection, within 12 months of your US application, you file applications in each of those jurisdictions. As you can imagine, 12 months is a pretty tight deadline to make all of your global filing decisions and to get those applications in. That's why the PCT, Patent Cooperation Treaty, offers a good resource to innovators. Basically, the PCT gives you an option that you can buy for additional time to get your filings in all the countries that you need. It gives you more time to decide. PCT covers most nations, but not all. All the big markets are covered: Europe, China, Brazil, Russia, India. Most markets are covered. There are some exceptions, such as Taiwan is sort of the classic example of a non-PCT nation. So for those exceptional, those unique nations that aren't covered by PCT, you do have to file directly in those nations as well. That's a pitfall that does not affect many applicants, but some applicants are affected by that. Once you have your PCT filed within 12 months of your first filing, you have another 18 months to get all of your international filings in. So the PCT gives you up to 30 months from first filing to select all of your nations for filing. That all presupposes that you filed the PCT application within that 12-month deadline of the first filing, though. Some countries give you an extra month on the PCT. However, to be safe, you should just keep in mind that 30-month due date. Just a quick note, many of our clients have this question. If you file your PCT before the 12-month deadline, say at the 10-month mark, you still have that full 30 months to get your filings in. Just a quick recap of the important deadlines to keep in mind. Get that first filing in prior to public disclosure. Then you have 12 months from that first filing to get your international filings in, whether they be direct or your PCT application on file. And that is within 12 months from first filing. Very important, unforgiving deadline in the patent law around the world. Then the PCT, if you file one, if you don't file everything by direct foreign filing, you have 30 months from your first filing to have or to get all of your applications on file based on your PCT application. Thanks very much for watching this video. This was the Decision Point edition on global patent filing deadlines. Again, this is patent attorney Steve Keefe. Please feel free to reach out to my firm at your convenience at any time. Thanks again.